What can be done if a debtor is fraudulently transferring assets as we're attempting to collect? Attorney Art Matthews explains, the only way a judgment or an amount that's due can be discharged is through bankruptcy. This means that a debtor would need to file bankruptcy in order to obtain a discharge of that debt. There are three main types of bankruptcy: Chapter 7, Chapter 11, and Chapter 13. The most common type of bankruptcy is Chapter 7 bankruptcy, which is filed by individuals and is considered a liquidation bankruptcy. An unsecured creditor who is trying to collect a judgment against someone who has filed for bankruptcy likely won't be successful because the debt will be discharged during the bankruptcy. The primary circumstance under which the unsecured creditor might be paid is if the debtor had assets that were liquidated, but this is very uncommon. The best way to avoid this situation is to move quickly to obtain a judgment. Once we have a judgment, we can record an abstract of judgment, which liens any real property that the debtor owns. We can also file a notice of judgment lien with the California Secretary of State, which liens any personal property, i.e. cars, stocks, and tangible and intangible assets that aren't real estate. Once we lien all of their property, we become a secured creditor. If a bankruptcy is filed more than 90 days after we record and file these liens, and we're a secured creditor, then we will be at the front of the creditor line in a bankruptcy. If a bankruptcy is imminent and we are already dealing with a bankruptcy attorney, then we may tell our client not to waste their time by filing lawsuits because they won't be able to get a judgment fast enough. However, if there is just the possibility of a bankruptcy in the future and we believe we have a viable claim, then we will file suit, get our judgment, and record those liens to protect our client. It's critically important to change a client's status from an unsecured creditor to a secured creditor, if at all possible. In California, a judgment can be enforced for 10 years from the date that it is entered, unless it's renewed for an additional 10-year term. It is not uncommon for people to receive a judgment and then just sit on it. The problem is that once a judgment expires, there's not a lot we can do to renew it. Collections are not like fine wine. They don't get better with age. It's better to move quickly when there is a viable claim. Matthews Law Firm's primary goal is to provide high-quality legal service for a fair and reasonable price. We welcome any opportunity to help clients fight for their corporate rights.